Hey guys, I'm gonna be starting defenses today. Sorry, American accent, force of habit. Anyways, I'm gonna go through all the defenses, and I'm gonna start off with insanity. Insanity may be able to be raised as a defense if applicable to scenario. The rules of insanity come from the case of M. Norton, where everyone is presumed to be sane. However, insanity may be proved at the time of committing the act. The defendant was labouring under such a defect of reason from a disease of mind as to not know the nature and quality of the act he was doing, or if he did know it, that he did not know what he was doing was wrong. Good introduction. There must be a defect of reason, so the defendant must be unable to reason at the time of the offence. This is because the basis of the defence is the defendant's deprivation of the powers of reasoning. So a person who still possesses powers of reasoning but cannot use them cannot be classed as insane. Same in the case of Clark. The defect of reason must have been caused by a disease of mind. Disease of mind is a legal concept to be decided by the judge. The court will have to make a distinction between internal and external factors. The first will be insanity and the latter automatism. In Bratty, a psychomotor epileptic seizure could amount to insanity. Kemp rules that the law is only concerned with the mind and not the brain. In Sullivan, it was epilepsy that was the disease of the mind. In Hennessy, the diabetes were classed as an internal factor, and Quick ruled the insulin to be external. If the defect of reason comes about through drink or intoxication, the defense will fail. That says Lipman. It's only applicable if it's an internal factor. So you'd have to use the case of Hennessy. Lastly, it must be proven that the defendant did not know the nature and quality of the act, and not knowing that the act is legally wrong. Even if the defendant has a defect of reason caused by a disease of mind, if the defendant knows the act is legally wrong, it fails. This was the case with Windle, as the defendant did not know the nature and quality of what he was doing was wrong. In Johnson, the Court of Appeal upheld the conviction as the defendant knew what he was doing was legally wrong. If successful, a special verdict of not guilty by reason of insanity will be given under Section 2 Trials of Lunatics Act 1883, and you have to mention that they might be sent to a hospital, mental asylum, or I think there's 4 different places where they can be sent, but that's insanity. Just quickly go over that with you guys. I think this will get you a sound. I'm pretty sure it will, because it has enough cases and stuff to go through the steps. As I said, practice with application and you should be fine. Take care, guys.